Welcome to your Video Download CLE course. This course was created to meet the requirements of state bars throughout the country. Therefore, codes have been embedded in this course. There will be one numerical code in a 1 credit hour course. There may be multiple numerical codes for courses greater than 1 credit hour. To determine if you need these codes, please go to the My Courses page. If your state requires these codes to receive CLE credit, please write down the codes on a piece of paper. Even though you may be watching this course offline, you will need to log back onto the website to obtain your certificate of completion. Further instructions can be found on the My Courses page by clicking any of the blue question marks or the Instructions button.
Hello, I'd like to welcome you to this CLE course on licensing. My name is Hanscom. I'm a patent attorney with Intercontinental IP in Carlsbad, California.
My name is Lionel Bochurberg. I'm a California and French attorney, and I have lots of experience in licensing, so hence my presence here.
Hi, I'm Todd Langford. I'm also with Intercontinental IP, and I'm a patent attorney here.
So we're going to talk about licensing today. There are 3 things that an inventor can basically do with an invention, and licensing is just one of the 3. So for the general practitioner who has an inventor show up at his or her office, a lot of times the inventor will be questioning exactly what they can do to try to make money off their invention. Well, there are basically 3 ways that I've seen that people can do it. The first is they can make it and sell it themselves. The second is they can assign their patent rights to another company or to a person, as in they sell their patent rights. The third is a rental of their patent rights, which is a license. And so we're going to be covering the third of those, which is licensing your patent rights to another person. First, though, let's go over some of the advantages and disadvantages of the different means by which an inventor can try to make money off their invention. So the first is making it and selling it yourself. Now, to a lot of the inventors, when they first walk into your office, they're going to say, well, I want to make it and sell it myself because then I get complete control and I get to keep all the profit. That's true. If you are the person who makes it and you're in charge of selling it and finding the retail outlets, that's true. You indeed do get to decide everything. You get to keep all the profit. However, you also get all the headaches. So real briefly, if you want to make it and sell it yourself, let's go through the timeline here. You've got a product. You probably shop it over to China, find a factory there that either makes that product or something similar, and you find the factory that basically has the assembly lines all set up to make it. So you have to go over there, find the factory, get them all set up to manufacture. And by the way, they want to get paid up front, at least 1/3 of the money before they start manufacturing. Once the products are finished, they're put in a container, usually a 20 or 40-foot container, thrown on a truck and taken across the border at Lo Wu into Hong Kong. Then they arrive at the freight forwarder. Now the freight forwarder's job is to take the containers and put them on the right boats heading over to California. Or if you happen to only buy several pallets worth, their job is to get your pallets into a container that's going to Long Beach with similar objects that aren't going to crush yours. So once the freight forwarder has done his or her job, the products are in the boat and they're heading over to California. Now, back before the recent recession and the increase in gas prices, you used to choose between fast boat and slow boat. Fast boat would generally make it from Hong Kong to Long Beach in 12, 13, 14 days. A slow boat generally would be about 3 weeks. Well, boats happen to operate like automobiles, which means that they operate most efficiently at partial speed, not full speed. So right now, the fast boats are taking about 3 weeks. Slow boats can take over a month, which has caused a major change in the way that small inventors are doing business with China, in that somebody has to pay for all the time that product is sitting on a container ship going across the Pacific. And so anyway, it's not quite as efficient to get goods manufactured in China as it used to be because of all the time they're just sitting on the Pacific, traversing the route from Hong Kong to Long Beach. Now, once they get to Long Beach, they have to go through customs. And once they go through customs, some retailers like you to ship it directly in the container to their headquarters. They then break it down, throw it into other containers that go on trucks that go out to the retail locations. Others like you to break it down, in which case you, the inventor, have to have a warehouse, usually in El Segundo or Long Beach, and you have to handle that. You also have to be in charge of getting the product to a store, and you have to have found a store that wants your product. Once you get the product to the store, you have to deal with all sorts of the intricacies of dealing with retail outlets, such as packaging requirements. Is the barcode the right place, the right size? Are there the right number of inner cartons for a master carton? Are the right number of products for an inner carton? Did the products arrive on time? And so there are all sorts of kind of rigmarole regulations you have to go through. Otherwise, most of the larger retailers will fine you for failing to follow these. You have to deal with things like advertising allowances, product placement charges, and things like that. You also have to account for all the goods that are made. And so you want to compare the manufacturing records to the freight forwarder's records, to the customs records, to the retailer's sales. And if 50,000 products disappeared somewhere there, you want to find out where they went. And there are a lot of unforeseen circumstances you also have to deal with when you're dealing with retailers. So if your inventor wants to make it himself or herself and sell it, great, all the power to them. They get complete control. They get to keep all the money that's left over. However, it's going to become more than a full-time job for one person. So the second route they can go. They can do an assignment of patent rights. Now, an assignment is basically a sale. And so you may say, I own the patent to this 3-membered nutcracker right here. I'll sell it to you for $500,000. Now, assignments are usually the second most desirable alternative to people who come into your office, because the idea of just selling patent rights and being done with it and just getting a big check is very desirable. The problem with that is that most inventors have a very twisted idea of how much their invention is worth versus how much somebody is going to buy the patent rights. So if somebody comes in with a patent on something and they say, I want $1 million for it, well, the prospective retailer is probably going to say, well, you've never sold one of these. How do I know it's going to work? I'm going to have to set up the factory. I'm going to have to do packaging. I'm going to have to market this. I can't give you more than $5,000 for it at this point. And so often with assignments, you have a huge disparity between what an inventor thinks the invention is worth and what a retailer or a manufacturer or a packaging company or anybody else who might want to buy the patent rights thinks it's worth. As a result, assignments usually don't go through very easily. And if they do go through at all, both sides are having to make major concessions. So the third alternative is licensing. And licensing is kind of both sides meet halfway. One of the attractive features of licensing is you can test market. It's kind of like trial dating before you have to marry somebody, in that you see how the relationship is going to work. You see if the person you're licensing your rights to can sell as many as they say, and the person who's going to be selling the products and manufacturing them, they get to kind of test the market, see if it's going to sell before they have to commit any serious money to the inventor. So anyway, licensing is often the third most attractive option to inventors, but it's often the one where they end up because they don't have the money to fund the whole thing themselves, and because they can't find anyone willing to pay them for the invention what they think it's worth.
But Eric, there's also some hybrid situation where you assign your patent, but in exchange of, let's say some down payment and some royalty, so that you would be associated with, the success of the product.
Yes.
So that it's not licensing, but it's close, because you are giving up the rights on the patents, the ownership, yeah, but you can still benefit from the success of the sales of the products.
Sure, and I think you'd have to compare that to a licensing situation where you're not giving up your patent rights. You still have them. You're just letting somebody else manufacture and sell the object. And I find perhaps with a sophisticated inventor, they'd be up for an arrangement such as the one that you're suggesting. I find with a lot of inventors, they're very paranoid about giving up what they see as their rights, because basically no matter how bad their invention is, they all think it's worth $1 million. And so they're just saying, I can't give up my patent rights for this. But yeah, with a sophisticated inventor, I think that would be a good approach.
And sometimes it's also a business model for non-practicing entity to come and say, oh, you have a very nice patent. Let me help you. Give me the property of the patent. I'm going to pay all the fees.
Sure.
It's also one of the things that is an advantage to license to assign is who pays for the fees for the US PTO and when you extend internationally. So the non-practicing entity would come and say, look, give me the patent and I would monetize it for you. You would I have strong arms and I can get lots of money because I'm a professional in the licensing.
Sure.
So that's also something that sometimes comes out of assigning the patent, but to get some return through the royalties.
And especially for a small inventor, often going to a company that's does this as a profession is a good route to go, because oftentimes an inventor will not be good at inventing, getting it made, doing the business end of things. They're better off finding somebody who can take over their invention partway through and trying to turn it into some dollars. Now, the other thing that goes on whenever you're dealing with assigning your rights and who pays the prosecution fees, what countries do you file in, I think you have to be very clear about who controls that and who pays for it, because obviously as an inventor, you don't want to leave all the decisions with your assignee, because they may say something, well, we want to file a surfboard patent in Mongolia, and you're the surfer and you're saying, no, it's never going to sell. And they're saying, well, I'm sorry, we're going to file it anyway, and by the way, we're taking that off of the net profits, so you're not going to get as much. So you want to maintain some control. At the same time, I think it behooves the inventor to approach such a relationship with the thought in mind that they're having to go to somebody to buy their rights because they don't have the money to do it themselves. So they may want to listen to the company and hopefully combine their knowledge to create a successful business.
Mm-hmm. And there are some certain situations where licensing is really your only option, like software.
Yeah.
If you invent something, you just can't, you're not going to necessarily assign each individual piece of code to the user. You have to license it. So sometimes, you say it's a third option. Sometimes it's the only option.
That's true.
That's true.
Yeah, if you're an average software developer, do you have the money to write the entire program, process it, do all the marketing? I mean, I think software licenses, they get on the average 7 to 11% or something like that. Do you want to take that and have Microsoft or Apple's clout behind marketing your product, or do you want to try to do it yourself on eBay? I'd rather take 1% of what Microsoft could do than try to hassle with selling it out of eBay and having the packages be in my garage. That'd be kind of a bummer. So when we talk about licensing, one of the important things is to decide what do you have that you're going to license out. I remember a conversation I had about 8 years ago with somebody who said, well, I'm just going to license out to an investor. And I said, what were you going to license out? And they responded, well, that's a good question. Okay, that's the kind of thing you probably should figure out before you're going to decide you're going to license out something, is what do you have that you're going to license out. Now, we're going to limit this to intellectual property, but with respect to intellectual property, you can license out your patent rights basically at any stage of the patent prosecution, from I just filed on this with a provisional to I have an issued patent in my hands. You can license out a trademark. You can license out copyrights. Basically, any type of intellectual property, you can license it out. So at the risk of boring any IP attorneys who happen to be watching, a patent gives you the right to exclude others from making, using, or selling the invention in the country in which the patent was granted. So for this little device, this is a 3-member nutcracker. The client in this case got a utility patent on how it works and a design patent on how it looks. We've also got a mouse pad here. This is made by the company called Funk. This is trademarked so that everybody knows this is a Funk mouse pad as opposed to being a Microsoft or an Apple mouse pad. So trademark protects the brand identity. Then we pulled this book off our shelves. This is called Selected Commercial Statutes 2006 edition. Probably not the most entertaining thing around, but anyway, they did copyright at least a portion of this book. So a copyright protects artistic creations, which in its traditional sense would involve books and magazines and musical performances and things like that. For your average inventor, you want to remember that a copyright can also be used to protect a website, packaging, owner's materials, things like that. Basically anything associated with an invention that could be called art, you can protect with a copyright. So you general practitioners and business attorneys, when you have the clients come into your office and you start talking about their options, and they say, oh, I don't need a copyright, that's just for Rolling Stones and the Beatles. You say, no, actually, it can protect your website. And that's, again, especially in this day and age, one of the most valuable things that you can have as an inventor is a website to show off basically what your product is all about.
One other thing to consider with what you have to license is whether you own it at all.
That's true.
There are many clients that come in and they've got an idea or they've come up with some new design for something, but as it turns out, somebody else made the design. They paid somebody else for the artistic artwork, or they paid somebody else for the actual inventive process. So when you're looking at what you can license out or assign or even manufacture yourself, you do have to be careful that you or your client actually owns that intellectual property before you attempt to license it out.
And also, when you are licensing in, you want to make sure that you are licensing to the right, party. That there's a clean, chain of title. Otherwise, you will be paying for pretty much nothing.
Exactly.
So it's and also one of the thing is as a due diligence is to make sure that when you want to manufacture something, you have everything covered. That. You may have to license in from someone else because it's also part of the process. So that's before licensing in or out, you have to make a determination of what's at stake in terms of the rights and who owns what. That's definitely the first step before.
What it is, and do you even own it?
Exactly. Exactly.
Yeah. And remember that a patent, to quote the statute, gives you the right to exclude others from making, using, or selling. It doesn't mean that you can necessarily make it. You may need to get somebody else's license to make your product. So, yeah, you've got to figure out all these things. It all goes into a business decision. Is this worth it? What am I getting, or what is my client getting out of this license? And does it make sense to go forward? If I'm licensing technology, I need more technology to license before I can even make it. Okay. So the first thing you need when you're deciding to license is you need something to license. So presuming that you figured out what you have that you want to license out, you need to look for prospective licensees. And there are a number of ways that you can do this. I'm a big fan of trade shows, and I tell especially a lot of our smaller inventors, I'll suggest they go on Global Sources or Alibaba or one of these Chinese sourcing websites and look at the trade show calendar and try to find some trade shows that are coming up nearby. Now, in my opinion anyway, the best trade shows are in Hong Kong, but here in Southern California, we have 4 decent trade show venues all within driving distance of San Diego County, where we're located, San Diego, Orange County, Los Angeles, and Las Vegas. And so I urge that they look for some trade shows that are coming nearby, and then check out the exhibitor list to look for companies that are practicing similar technologies. These companies, they could be your competitors, they could be your licensees. So often you want to start compiling a list, and I suggest people do this on an Excel sheet so they can alphabetize it, do that sort by row function, so they can keep looking, and if the same prospective licensees keep coming up time after time, that's probably somebody that they should try to meet by going to a trade show. And now again, obviously, you want to be patent pending before you go to the trade show. I shouldn't have to say that, but I do. You'd be amazed how many situations you hear about or you run into where somebody says, "Yeah, I went to a trade show 3 years ago and I had a booth, and now I want to patent my invention. Can I?" Well, probably not, because you did a pretty major public disclosure at this trade show if you changed your invention any. But so you want to make sure that the timing's right there. And so anyway, trade shows are a good way of figuring out some people you might want to license to. Retail outlets are another good source. So if you happen to have invented something like this is a salt shaker that has a beveled weighted top. So after you're finished shaking out your salt, you flip it right side up. The beveled edge just seals off the water vapor, so you don't end up with a bunch of coagulated salt in your salt shaker. If this is your invention, well, you probably can go to Crate and Barrel, see who makes similar products. You could go to Costco, you could go to Walmart, Kmart, Vons, Ralph's, see who makes these type of salt shakers. These could be the people you could try to license to. Now, when you're looking at a product, the other thing I think that's worth considering is you generally have 4 levels at which you can try to license. We'll just keep with this. The first is you could go to the actual manufacturer, which is a company in China that makes items similar to this. You could go to that company and say, "Hey, company, I've got the rights to a really cool new salt shaker. Would you like to take over these rights and start making this?" You could also go to a packaging company. Now, I use the term packaging company to cover a company that doesn't make it and they don't sell it, but they put it in their packaging. So a packaging company goes over to China at a trade show. They look at the 100 or so products out there and they say, "Can you make these 3 for me? Here's what I want the packaging to look like. crank me out a 20-foot container load, we'll bring them over and try to sell them. So you could go to the packaging company. You could also go to the retailer. You could go to like a Crate and Barrel and say, hey, you want to be the only person who can make this. I don't care where you get it made. I don't care whether you put it in your packaging or your house brand's packaging. Just get it made and pay me. And then the last level at which it isn't really a license, but you can try to sell it, is you can sell it yourself. And you're talking about a fulfillment house or eBay, something like that. So there are a number of different levels at which you can try to license out a product.
But when you say you want to sell yourself, so that means that it's also the beauty of the licensing is that you can also reserve the right to sell.
Mm-hmm.
You can just make sure that you can allow for certain territories, for certain products, for certain markets, and so it's not the all or nothing. You can just adjust and fine tune according to the market needs, basically.
Well, that's the great thing about licensing is that there's so many different options, so many different ways that you can form a license. As you said, there's territories, exclusive, non-exclusive, time periods. We'll get into a lot of this stuff in a minute, but it really is almost the sky is the limit as to how you can, structure such a deal. You may take care of everything but the actual selling part. Or you may have everybody else, you license other people to do everything, then you just do the final selling yourself. So, as you say, there's so much you can do.
I tend to, object to the skies of the limit because you may have the antitrust laws as the limit in terms of what you can do in terms of...
it's not the universe, it's just the sky.
Yeah, it's the sky, okay.
Yeah. So what I find often is when we're discussing these issues with clients is that I urge them to try to keep control over the things that they really like and they're really good at. These are not necessarily the same thing, unfortunately. But if you find a client who's really, they love traveling to China, they love overseeing factories, they love going to Hong Kong and having the fancy dinners and attending the trade show with their manufacturer. If they really love that, then maybe they're cut out for that. If they've never traveled outside of the United States before, probably overseeing factory management is not something that they're going to want to do. If they've got a family at home, that's what I hear quite frequently. I can go to Hong Kong, but only for a day. Well, okay. You're not even going to be able to go there for a day. You're going to go there for 30 minutes, and you can't even get into Hong Kong from the airport in 30 minutes. So you're not cut out for that section of the invention process. But I think that's really worth doing is sitting down with your client and figuring out, what do you like doing? What part of this are you good at? What can you do? And what can't you do?
Yeah.
It all comes down to, it's a line from the first Pirates of the Caribbean movie where Captain Jack Sparrow turns the boom into the Will Turner character, and he's out there hanging. And Captain Jack Sparrow says it all comes down to what a man can do and what a man can't do. So it's got to be the same thing as a client. What can you do? What can't you do well?
Did you get a license to use that phrase?
No, I didn't.
It was a fair use privilege.
Jason, you're going to cut that out, right? So assuming now that you know what your client wants to license out, and assuming that your client has found a prospective licensee, you have to prepare for approaching your prospective licensee kind of like an inventor would approach a potential investor. And the better prepared you are, the better a chance you have of landing a good licensing agreement. So if your client has prepared a provisional patent on elcheapoprovisionals.com and they have a prototype that they made in their garage with a hammer and a vise, and their business plan is basically, I'm going to go out and sell this thing, you're probably not going to get a very good licensing deal. So, in terms of the preparation you want to go through, what I always tell our clients is I suggest they look at a quick pitch competition. And there are a couple of good quick pitches that I've seen. Here in San Diego County, we've got the Tech Coast Angels quick pitch, and then there's the Cal State University San Marcos quick pitch. And there in 2 minutes, these people have to have down basically an entire business plan. So I definitely think it's worth mentioning to your clients that they want to come up with a decent business plan, because any prospective licensee is going to want to figure out what they're getting. And again, if they're getting a provisional patent that was written on the back of a napkin and a crummy little prototype, you're not going to get a very good offer. Whereas if you can convince the licensee that maybe it isn't an ongoing business, but at least it's a proven product, that it's got some good intellectual property in place, that you've done your prototyping work with some quality engineering firms, that you've gotten maybe the opinion of an engineer that this will indeed work, I think you're going to greatly enhance your chances that you're going to end up landing a licensing deal that your client will be happy with.
But that's the situation where the prospective licensee is not manufacturing or selling a product similar to what's in the scope of your patent, because that is a completely different animal in terms of the approach. You have to be careful not to threaten the prospective licensee, which also is a potential infringer. So you have to play it very nicely with your patent attorney to make sure that you are not going to trigger a reaction from the prospective licensee slash infringer that could launch a counterattack by the way of a declaratory judgment.
You don't want to start a prospective licensing agreement having to defend against a declaratory judgment, that's for sure.
But we are what you are contemplating more the situation of you want to convince of a new invention, a new product, and someone who would take over hasn't thought about it, and you have to convince as an investor that it's a good solid business plan.
But your point is a good one. It brings up another point that I think that we probably need to reiterate here, and that is that your potential infringers, your potential copiers, they are also, in many cases, your best potential licensees. And so you do, especially you're talking about patent rights, you do have to be careful going out there and rattling your sword. And there are unfortunately cases out there that basically say an invitation to a license can spawn a declaratory judgment. So, exactly how do you word that first approach? That's an important issue.